So that make, the it very much exhaustive, that the evidence, whether it is oral or the documentary, can only be given in the court to prove or disprove either fact in issue or the relevant fact. If a particular fact is not relevant, because you are not able to show that under which section it is relevant. So if that fact is not relevant, you will not be allowed to give the evidence. And then there is one explanation that applicable to the civil case, that illustration is that explanation is attached, and that says that suppose there is some fact that it may be, you know relevant, but it is not allowed to prove, like in the doctrine of estoppel. So in that case, you know that this particular section will not enable such person to give the evidence, because it has been inadmissible, or it has not been allowed by the some express provision, like in case of estoppel section 115. Okay. Then section 6 we discussed, and section 6 make certain facts that, though not in issue, but they are related to fact in issue in such a manner that they make the part of the same transaction. Maybe that particular fact is not taken place, or there is a gap between the time, or there is a gap between the place where this particular fact happened. But because it formed the part of the same transaction, that's why those facts that form the part of the same transaction would also be relevant. And very interesting and relevant and understandable illustration has been provided, that there is an allegation between on the A, that A has written a defamatory statement or a defamatory letter, that is known as libel, to B. So all previous letter that form the conversation that result into this libelous letter would also be relevant, though the earlier letter had been written previous time. So time ke hisab se they are not at that particular point when this fact in issue, that libelous letter happened, but because they are related to the this particular fact in issue, so form the same part of the same transaction, that's why they are related. And this particular provision is basically known as res gestae, RESGESTAE. Then the next section that we had discussed is section 7, and under the section 7, the 5 things we have discussed. So the occasion that result into the either fact in issue or the relevant fact. Cause, the cause related to fact in issue or the relevant fact. Effect, and 2 other things, that which constitute state of thing under which this happened, or the facts which afforded an opportunity. So on these 5, or you can say these 5 facts are also be relevant by virtue of the section 7, and these facts can also be proved or disproved by adducing the evidence as according to section 5. And there, that a person before the robbery went to the fair, had the money, he had sold this money to some other person. So these facts will also become relevant, because these are the somehow related to section 7, the occasion or with respect to the cause, that A had murdered B, or you can say uh, A had borrowed money from the B. So maybe that at time B had the urgency or the need in the money, maybe one cause. Effect that the mark of struggle where the murder happened, or in case of murder by the poison, the illness, or you can say the effect that caused to the body of the victim are known as can also be relevant under section 7, and whose evidence can be given. Then section 8, the last one, three important thing: motive. And motive is very important in the criminal trial, especially when there is no direct evidence. When there is the direct evidence, suppose the allegation is on the A that A caused the murder of B, and there is eyewitness C who saw all the event and he gave the testimony. So उसमें तो कोई क्वेश्चन ही नहीं कि एक ए ने बी को क्यों मारा, क्या मोटिव होगा. But suppose the direct evidences are not there, and in that case the circumstantial evidences, the chain of evidence will complete when you saw the motive. Like A murdered B, and earlier A murdered C, and B know that A murdered C. He used to exploit the money. So just to ये पूरा खेल खत्म करने के लिए कि ऐसे तो बी एक्सप्लॉइट करता ही रहेगा इस फैक्ट को, ए ने बी को भी मार दिया. So that may be the motive, and these facts you can prove by any evidences. Okay. Then the preparation. So the preparation and the previous and subsequent conduct. There is a difference between the preparation and the previous and subsequent conduct. Preparation means those steps that are necessary to commit that crime, or that are necessary to do that particular thing. And previous conduct means all other conduct that shows that it somehow give the hint or the direction or refer towards the commission of the offense. So that thing. And the subsequent conduct means the conduct of the person. It may be the accused, it may be the victim, that shows or somehow infer towards the commission or towards the happening of that event. That right after the rape of a particular victim, she went to the police station, and the condition in which she went to the police station, the whole clothes are torn out, her hairs were in messy, and bleeding also, etc. So all these things shows the conduct that after the commission of the offense, she directly went to the police station. Someone says, another in the station, that C says that police is coming to catch the offender, and on listening this, this person A just left that place. So that may be the relevant conduct that to give the inference that this person has committed. So here section 6, 7, 8 made many other facts as a relevant fact. Here only these section making the relevant, but how much these facts would have the evidentiary value, that is not mentioned. That depends on the case and the overall you can say circumstance in that particular case. Another thing is that these provisions are making that particular fact as relevant. After making the relevant, it is your ingenuity and your evidences, that by those evidences you are able to prove or you are not able to prove. Okay, that is the another things. Like you want to say about the motive. So as such motive you can prove, but maybe you do not have the that oral evidences. जिस बंदे को आपने ने कहा था कि हाँ मैं बताऊंगा ये motive था, maybe he became hostile. So as such motive, for the motive you can prove, you can, as such it is relevant, the evidence you can give. But whether you will be able to prove or not, that depends on the quality of your evidence. What would be the evidentiary value? That is also not certain here. Section 9 and 11, that is in our schedule today, that we would discuss, it is somehow related to hearsay or evidence. But as an exception of hearsay, we, or you can say the Evidence Act, make these facts are relevant. But that does not mean they conclusively they will prove it. But definitely, maybe in line or in connection with the fact in issue or the relevant fact, they would infer something. Okay, so that is the evidentiary value. So with that, today discussion we can start. The first section I'm taking is the section 9. And the section 9, making certain facts as relevant fact. Why relevant fact? Because they are related to fact in issue or some other facts. Okay. What are those facts that section 9 is making relevant? If you read the marginal note, you will get confused that marginal note of the section 9, marginal note होता है जो आप बेयर एक्ट में पढ़ोगे तो एक सेक्शन 9 के बाद में एक मोटी सी जो लाइन होती है, fact necessary to explain or introduce relevant fact. And आपको लगेगा कि बस ये इसी सेक्शन को कवर करता है कि those fact that are explain or introduce the relevant fact that are also relevant. But no, when we read the section, there are certain other things. Basically, you can divide and can say 5 things that section 9 making relevant. The first one is facts necessary to explain or introduce fact in issue or relevant facts. And this thing, I think I have already told you that every section, using this word fact in issue or relevant fact. And that's why this create like a web of the spider. If particular fact is res geste fact is relevant because it forming the part of the same transaction, something that is relevant to introduce that res geste, that would also be relevant. Try to apply this in like that important, or you can say the famous illustration where I'm taking, that A wrote letter to B. A ने B को एक letter लिखा, and in that letter there were so many defamatory things, and this letter fall to the some other person. So Mr. B filed the case of defamation against A. Okay, and in that trial, the criminal defamation under section 499 read with section 500 IPC, the question arose, and this B want to give the evidence of earlier letter communication that form the part of the conversation. जो पहले लेटर लिखे, उसने कहा कि सर मैंने तो ये इसलिए लिखा, ए ने कहा कि मैंने तो इसलिए लिखा क्योंकि बी ने मुझे ऐसा इंस्टिगेट किया या इस तरह की चीजें हुई. अब ए ये चीजें प्रूव करना चाहता है अर्लियर लेटर को भी. सपोज इन दोनों के बीच में क्या रिलेशनशिप था, उसको इंट्रोड्यूस करने के लिए कोई दूसरा फैक्ट है कि जी हमारा रिलेशन जो था, हम एक साथ जो है मुखर्जी नगर में पहले दोस्त थे, एक साथ पढ़ाई करते थे, तैयारी करते थे. सो दिस फैक्ट इज explain this whole thing or introduce. So this fact can also be, you can adduce. Okay, you have seen that in the trial, before questioning a witness as to the main fact, generally desirable and sometimes necessary to question the witness about some preliminary facts. Such preliminary facts may have no bearing on the facts in issue, but since they lead to the main fact, they are made admissible under the section so as to make main fact more easily comparable. आपने कभी ट्रायल में भी देखा होगा कि जब वो एविडेंस देने जाता है तो उससे पूछते हैं कि आपने इस भाई साहब को उस दिन देखा कि ये कुछ गड्ढा खोद के दबा रहे थे, तो उससे पहले पूछते हैं कि आप कौन है जी? मैं राम सिंह हूँ, इन्हीं की सोसाइटी में इनके सामने वाले फ्लैट में रहता हूँ, और शाम को मैं बैठ के बालकनी में स्मोकिंग करता हूँ, तो उस दिन भी स्मोकिंग कर रहा था और फिर मैंने ये चीज़ देखी. सो मे बी द रिलेवेंट फैक्ट इज just to is that how much it is that particular instance, but all these facts that are necessary to explain would also become relevant by virtue of section 9. Okay, and under section 142 court may permit even the leading question on the introductory matter. Now अब ये leading question क्या होता है? Section 141 Section 141 of the Indian Evidence Act that talk about the leading question, and it says that leading question, leading question is that question that suggesting the answer which the person putting it wishes or expects to receive. जैसे आपने विटनेस बुलाया, उसी से पूछते हो आप रामलाल हो? उसने कहा हाँ. अच्छा, उस दिन आपने क्राइम होते हुए देखा था? वो कहते हैं हाँ. अच्छा, इनके हाथ में छुरा था? वो कहते हैं हाँ. तो उसने एविडेंस किस चीज का दिया? उसने टेस्टिमनी क्या दी? गवाही तो कुछ दी नहीं. सो इस तरह के लीडिंग क्वेश्चन जो आप आंसर चाहते हो उसकी तरफ इशारा करें, दैट यू विश और एक्सपेक्ट, उसकी तरफ इशारा करे, दैट इज नोन एज लीडिंग क्वेश्चन. एंड एग्जामिनेशन इन चीफ और री एग्जामिनेशन, यानी एग्जामिनेशन जब होगा, जब कोई भी विटनेस आएगा, तो उस समय आपका काउंसिल है वो लीडिंग क्वेश्चन नहीं पूछ सकता, वो खुद बताएगा ये है ये. आप पूछ सकते हो आपने क्या देखा, बट आप ये नहीं कह सकते हो कि उस दिन आपने मर्डर देखा. उस दिन आप ये कह सकते हो कि आपने उस दिन क्या देखा? अच्छा जी मैंने ऐसे किया, उसके बाद में क्या देखा? But leading question you cannot ask. But with respect to then the section 142, that when the leading question can be asked, so there leading question must not be asked. So section 142 says that in examination in chief or re-examination, leading question cannot be asked. But then there is the you can say the latter part of section 142 as an exception, that court shall permit leading question as to the matter which are introductory. So in introductory facts, even the leading question may be asked. So the first portion of the section 9 talking about those facts that explain or introduce either fact in issue or relevant fact. Okay, like the motive is now the relevant fact under section 8. So when a person is coming to the court and he is giving an oral evidence regarding or somehow that prove the motive of the accused, the other facts or other things that he will state that introduce or explain this motive part of the accused will also be relevant fact, and that can also be given before the court. So first is the facts that explain or introduce fact in issue or relevant fact. The second is which support, that means the facts which support or rebut, either support or rebut inference suggested by fact in issue or relevant fact. Suppose a particular fact is the relevant fact, and this relevant fact is suggesting or inferencing something. So other fact that either support this or rebut this would also be relevant. A very interesting and very beautiful explanation is there in illustration. Okay, that C, illustration C. A is accused of crime the fact that soon after the commission of crime, A absconded from his house is relevant, okay, under section 8 as the subsequent conduct. कि भाई A ने crime किया, उसके बाद में वो चला गया था घर से, so he absconded from the house. This is relevant because it shows the subsequent conduct, and so under section 8 this fact you can prove, okay. Yes, the fact that at the time when he left the home, he had sudden and urgent business at the place to which he went is relevant as tending to explain the fact he left the house suddenly. So the the fact that he had a business, and with respect to that business he had an urgent work, an urgent thing to go to that place where it was alleged that he absconded, is also became relevant, okay. The another yes, the detail of the business on which he left are not relevant except in so far as they are necessary to show that business was sudden and urgent. The detail of the business may not be relevant, but it was urgent, and that's why he absconded, just to show that details would also become relevant. Otherwise that details would not be relevant, but the details that showing the urgency, अब वो क्या काम करता था, क्या काम नहीं करता था, that would not be relevant, but just to show that how much urgent it was. So in that case, that much of the detail related to his business can also be also became relevant. So this is the second thing, that facts which support or rebut the inference suggested by fact in issue or the relevant fact, okay. Now the third thing is the fact which establish the identity of anything or the person whose identity is relevant. The fact which shows the identity of anything or the identity of a person which is relevant. In case of the crime, that two things has to prove: the ingredients of the crime, and with that ingredients it has to be proved that this particular thing has been done by this particular person against whom this allegation is there, the trial is conducted. So like the death is caused, in case of murder, this fact would be in issue, that death is caused, the death is caused by, if it is stabbing, by the stabbing. Then the third thing is that it was caused with the intention, and these facts are related to, like the allegation is against that A caused the death of B, or A stabs B by stabbing B, B's death was caused, A was intended to cause B's death. Now here, to prove the identity of A, the evidence can be given. So to the witness you can ask that, or to any person as a witness you can ask that, have you seen this man who stabbed B? And he can say that yes. In criminal trial, test identification parade, TIP, is conducted. Suppose there is a case of this gang rape, and in the gang rape the allegation is against 4 persons. So victim has to recognize out of those persons that whether these are the person who committed rape on you, And the witness who is also giving the evidence as an eyewitness also has to recognize, because the identity of the person is here relevant. And so the person, this fact of proving the fact that is necessary to prove the identity of this person would also become relevant by virtue of section 9. Section 410 of the Indian Penal Code that talk about the offense of taking the stolen property. In case of the stolen property, the property also has to be identified, that the person who has taken this property, whether this person has taken, so that also has to be identified, because without identifying the property, without establishing that this is the property that already has been stolen, the offense of the section 410 would not be proved. And so by virtue of section 9, the facts that proving the identity would also become relevant. So the this third one, that fact which established identity of anything or person whose identity is relevant would also become relevant. So with that, three things so far we have discussed under section 9. I am repeating again so that you can remember it. First is those facts that are necessary for explaining or introducing fact in issue or relevant fact. Explaining or introducing. Second is facts that either support or rebut the inference suggested by fact in issue or relevant fact. The third is the fact which establishes the identity of anything or the person whose identity is relevant. So the identity of person or anything, that would also be relevant. In the test identification period, where the question become very relevant, that whether these person have committed the offense or this particular person has committed the offense, the test identification period is done. But when the accused already know the victim already know the accused, or when the witness already know the accused, in that sense the test identification period is just a farce, has no value. But when the victim, yes, so Udichi asked some question. I'm just taking that question. Sir, if accused is identified by witness in TIP as well as in court, would that be enough for conviction? No. See, the test identification period has to be done in the court only. So the word that you have written as well as in the court, the TIP period as well as in the court, identified by the witness in TIP period as well as in the court. TIP is always done before the magistrate, before the court, you can say. And there are certain rules also, that in test identification period, similar person would be shown, and the ratio of the person, how much would be the ratio, that is also certain. So similar height, similar body build up के persons को दिखाया जाएगा, and in that you have to identify. Okay. The next thing is that this is just a step towards the investigation. It would help in the investigation, and no other value is done in the TIP. उससे ज़्यादा TIP की और ज़्यादा value नहीं होती. But yes, definitely it would be helpful in the investigation, that whether investigating agencies are going in the right direction or not going in the right direction. Suppose investigating agency ने आपने कहा कि जी 2 लोग, there were 2 person who gang raped me, okay, and the police have अपने वो sketch भी थोड़ा सा बताया. Police have arrested 2 person. When they produce in the test identification parade, उनके 2 के साथ 8 और लोगों के, और आपने आइडेंटिफाई किए उसमें से जो 2 थे, उसने कहा कि नहीं नहीं, इन 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 10 में कोई भी नहीं है. ना तो वो 2 आपने रिकॉग्नाइज किए, ना उन 8 में तो कोई तो होना ही नहीं था, वो तो अलग से थे. So that means police has not going in the right direction. The person who the police have arrested have not committed the crime. And so this trade identification parade is not the conclusive evidence, and it is not sufficient for doing the conviction. This question has asked by the Udichi. So it would not be the sufficient evidence for the conviction. The only importance or the significance of the trade test identification parade, or you can say TIP, is that it confirms whether the investigating agencies are going in the right direction or not going in right direction. And even in case of the witness, also to test the veracity. So that is only the purpose of the test identification parade. Yes. Now there is 2-3 lines I want to read that would be important. That when accused is, as such I already had said, that when an accused is not previously known to the identifying witness. Here identifying witness also include the victim also, because victim is also as a witness. Victim is also a good witness. As in case of dacoity, identification parade are generally held. If the accused is already known to the witness, the identification of witness is just a force, or you can say that is not required also. That TIP are not primarily meant for the court, as Udichi, you have asked. They are meant for investigating purpose. The object of conducting TIP is twofold. First is to enable the witness to satisfy themselves that the prisoner whom they suspect is really the one who was sent by, who was seen by them in connection with the commission of crime. Second, to satisfy the investigating authorities that the suspect is the real person whom witness had seen in the connection with the said occurrence. So that much is the importance. But these facts can be proved, this TIP can be done. You cannot say that why this TIP, why this whole thing is done, because this is also relevant under section 9. Now come to the fourth important fact that section 9 made relevant. The fact that fix the time or the place at which any fact in issue or the relevant fact happened. Yes, sometimes this identification of the person is also done by the photograph. By the photograph also this identification is done, because the section 9 making that the fact where the identity of anything or the person. So, or sometime leaving this anything, where the identity of the person is relevant. In that case, this identity can be proved, and how it has to be proved is not Rahul just
ये जम गया है ना, this is the most dangerous.
Rahul,
अगर इसको स्मोक करते ही साफ कर लिया ना, सर्फ से भी कर लिया, then it's no problem, then it's long life.
Rahul is explaining all the. Yes, Rahul, unmute yourself.
यार मैंने पढ़ा तो था बहुत पहले.
Mr. Rahul, unmute yourself. Yes. So section 9 is not saying that how it will be done. So TIP is one method. Sometimes this thing is done by proving through the photograph. And in identification of the photograph, the Supreme Court has held that the identification of the photograph, it was from the Umar Abdul Sakur Sarathia versus Intelligence Officer Narcotics Control Bureau. So in that case, the Supreme Court, or if you want to write this case, you can write it Umar Abdul Sakur Sarathia. Umar Abdul Sakur Sarathia versus Intelligence Officer, Narcotics Control Bureau, Intelligence Officer, Narcotics Control Bureau, 2001 SCC on the page number 138. The Supreme Court held that identification by photo is admissible in evidence for framing charges. However, the evidence would become substantive evidence on identification by witness of the accused in the court. During the course of investigation, if witness has given the identifying feature of the assailant, the same could be confirmed by investigating officer by showing the photograph of the suspect, and he shall not first show a single photograph but show more than one photograph. So the way in which the TIP is done, in the similar way through the photograph also that identification can be done. Okay. Now come to the fourth one, that the fact that are necessary to fix the time or place at which any facting issue or the relevant fact happened. The conduct, subsequent conduct, where that subsequent conduct happened. So if that subsequent conduct, where it happened, or the time when this subsequent conduct happened. Suppose apply that illustration that after the commission of that offense, this B said that police is searching for the offender, and after listening this, A has left that place. So the time at when this particular thing happened, that would also be relevant. Whether just after that, this particular offense, or maybe 1 day or 2 day after it, this particular instance of leaving that place by A happened, or is it was for after 1 month or 2 months, so or maybe after some more time. So in that place, in that case, the fixing of the time would also be relevant, and any fact that fix the time, so that fact would also become relevant. So the fact that fix the time or the place of the relevant fact or fact in issue, so that fact would also become relevant. Then the fifth one is that facts which show the relation of the party by whom any such fact was transacted are relevant in so far as they are necessary for the purpose. Okay. Here, the relationship of the parties by whom any fact was transacted. So, suppose the dacoity or robbery happened, and A, that means the A was robbed in a fair. मेले में गया था A, and it was robbed by B. The fact that A went to the fair, that is also became relevant. The fact that he had money at that time is also relevant. He had shows this money to the B would also be relevant under section 7. And the question that why he showed the money to the B, ऐसे कोई पैसे थोड़ी दिखा देता है कि हाँ मेरे पास पैसे हैं. The relationship कि A and B were friends, the business friends. So this relation that by whom this transaction is conducted by B, that who robbed, against whom there is the allegation. So the relationship or the fact that showing that both A and B were business friend or were the friends, this fact would also be relevant. And if you apply section 9 read with section 5, the evidence of showing that B was the friend of A can also be adduced. So This is the fifth one. The fact which showing the relationship of the parties by whom any such fact was transacted, any such fact was done, if that is relevant, so for that purpose, that relationship can also be proved. Or you can say the section 9, if you overall see all these five, section 9 cover all other facts that are necessary either to explain or introduce, or to support or rebut any inference that is done by any relevant fact, or the facts that establishing identity of anything or identity of person, the fact which fix time or the place of the particular fact in each or relevant fact, or the fact that showing the relationship. So all other peripheral facts that related somehow to the earlier relevant fact made by the section 6, 7, 8 would also be relevant. Okay. Sir, what does identity of anything means? Identity of anything means the identity of, like in the offense of murder, that is done by the revolver, the bullet, the revolver. In the murder, the offense committed by stabbing, so the dagger or the knife. So the identity of the knife, if that has been established, so the fact which establish the identity of that particular, the forensic report आएगी जो ये बताएगी कि चाकू का ऊपर का सिरा जो है वो थोड़ा सा मुड़ा हुआ है. The movie that I referred you, or you can say I suggested you before beginning our classes, Criminal Justice. So in that Criminal Justice first, the evidence that the knife by which it was alleged to have committed the murder of the girl, that knife have very sharp tip, and in the report it was the expert opinion was given that when the stabbing is done, so knife goes to the fleshes, so उसके ऊपर के टिप है वो थोड़ी सी मुड़ जाती है. इस केस में ऐसा नहीं है. So anything means any particular, yes, sometime in the section like 410 I have given the offense of getting the stolen property. So उस केस में भी stolen property का identity important है. Theft में आपने कहा कि इसने मेरा अम्ब्रेला चुरा लिया, उसके घर से पुलिस ने अम्ब्रेला रिकवर किया कि भाई अम्ब्रेला हुआ, बाद में आपने कहा नहीं ये तो मेरा अम्ब्रेला नहीं है, तो जो आप फैक्ट यहाँ पे दोगे कि आपका अम्ब्रेला नहीं है, आपने कोई फोटोग्राफ दिखा के दी, नहीं मेरा अम्ब्रेला नहीं है, मेरा अम्ब्रेला तो ऐसा था. ओके, सो दिस इज समथिंग. So anything means other than the human being, it may be the particular weapon. So like in the, if the through the car, through the negligence the murder done, तो आइडेंटिटी ऑफ द कार हैज टू बी स्टेब्लिश. अच्छा ये वही कार है जिससे आपने देखा था कि बड़ी तेज स्पीड से आती जा रही थी, एंड दैट देन इट रैम्प इनटू द सोप, और उसके बाद में उस सोप में 4 लोग मर गए. सो दैट एनीथिंग इंक्लूड ऑल दोज थिंग्स. ओके, some illustration I am reading, and that would be more helpful to understand this you can say the scope of this section. Illustration first, or illustration A, the question whether a given document is will of A. क्वेश्चन ये है कि एक डॉक्यूमेंट है, विल का डॉक्यूमेंट है, क्या ये डॉक्यूमेंट जो विल जो है ये ए की ही विल है, ए भाई साहब की ही विल है क्या, या द स्टेट ऑफ एज प्रॉपर्टी एंड ऑफ हिज फैमिली एट द डेट ऑफ अलेज्ड विल, उसके ए की प्रॉपर्टी का क्या स्टेट था, कितनी उसकी इनहेरिटेंस प्रॉपर्टी थी, कितनी उसकी सेल्फ अक्वायर्ड प्रॉपर्टी थी, कहाँ प्रॉपर्टी स्टेट ए में थी, कौन सी प्रॉपर्टी डिस्ट्रिक्ट बी में थी, एंड उसकी फैमिली में कौन कौन थे. तो ये चीज़ें भी रिलेवेंट हो जाती हैं. So the state of age, property and of his family at the date of alleged will may be relevant fact. relevant fact, because these facts are introductory of the will. Okay. A, illustration B, A choose B for libel imputing disgraceful conduct to A. B affirmed that the matter alleged to be the lascivious is true. You know, in case of offense of defamation, that the matter you have said is true is the exception or is the justification. The simple word you understand. See, reputation is as much recognized as the part of a man's property, or you can say related to man. Okay. And it is recognized in eye of law. And the offense of defamation means कि आपकी जो वैल्यू है लोगों की नजरों में, इस आदमी ने अपने कुछ कहने या पब्लिश लिखित या मौखिक रूप से इसके कहने से आपकी जो इमेज है वो लोअर डाउन हो गई. So that is offense of defamation. But whatever you have said वो ट्रू था, so that would not be a defamation, because सही बोलना कोई ये नहीं है कि वो गलत है. So in the offense of defamation, when you shows that suppose there is the allegation कि आपने पेपर में लिखा कि बी जो है चारा चोर है, आपने कह दिया कि ये देखो जी फैक्ट है, इस पे देखो है वो चारा चोर. या आपने कहा कि बी जो है उसने 30 तारीख 2019 को चोरी की थी, और इससे बी को बड़ा गुस्सा आया एंड ही हैज फाइल्ड डिफेमेशन केस. कोर्ट में आपने जो है वो जजमेंट प्रोड्यूस कर दिया जिसमें उसको कन्विक्ट किया हुआ है. सो दैट इज समथिंग दैट यू आर वांट टू शो द ट्रूथ. सो इन इलस्ट्रेशन बी दैट ए ने शू किया, शू मीन सिविल एक्शन. डिफेमेशन इज क्रिमिनल एज वेल एज सिविल एक्शन. सो सिविल एक्शन उन्होंने किया कुछ कंपनसेशन के लिए. क्या होगा कि ही हैज डिफेम मी, ही हैज लॉवर्ड माय रेपुटेशन इन आई ऑफ राइट थिंकिंग पर्सन, and so he has to compensate me by giving this much of the compensation. And you the B against whom there is an allegation affirmed that this matter is true. Now the question that how the relationship of these party, कि बी कहे कि भाई मैं तो इसके फैमिली का मेंबर हूँ, इसका जीजा लगता हूँ, इसका साला हूँ, या इसका ब्रदर कजन हूँ. So this position and relation of the parties at the time when the libel was published may be a relevant fact as introductory to the fact in issue. Okay. And by other way, if you see, it is also relevant by the fifth one, that it shows the relationship. Now the other fact by which it establishes that yes, the relationship between them is of the cousin, that fact would also become the relevant. Okay. So both would be relevant. Now come to the there is another thing, that particular of the dispute between A and B about the matter unconnected with the alleged libel are irrelevant, though the fact that there was a dispute may be relevant if it affected the relationship. The other fact that there was the dispute between A and B, that would not be relevant, but that dispute जो है वो उनके relationship को खराब किया या उनके relationship को किसी भी तरह से affect किया, so that would became again became the relevant, because it is again the explanatory or the introductory. Then illustration C, that A is accused of crime. The fact that soon, I think we have discussed it. Then illustration D, A sue B for introducing C to break a contract of service. Breaking and instigating the contract of service, that is also offense. So C on leaving a service, so C कॉन्ट्रैक्ट तोड़ के जा रहा था, उसने कहा कि भाई साहब मैं आपका कॉन्ट्रैक्ट क्यों रखूंगा, इससे ज्यादा ऑफर तो मुझे बी ने दिया है. दिस स्टेटमेंट वुड बी relevant because this statement explain the conduct of Mr. A ने क्यों तोड़ा वो कॉन्ट्रैक्ट ऑफ सर्विस, बिकॉज बी ने उसको ऑफर दिया था. तो दैट स्टेटमेंट कैन आल्सो बी became relevant, you can prove because it explain the conduct of A. Okay. Then there is clause E, illustration E. A is accused of theft, is seen to give the stolen property to B, who is seen to give it to A's wife, and B says, as he deliver this property to his wife, that A say, you are to hide this. B's statement is relevant as explanatory of the fact which is part of the transaction. But if you see from the other perspective, simply I'm in the simple language, no, there is the allegation that A is accused of theft, is seen to give that stolen property to B. A पे चोरी का इल्जाम है, उसने वो जो प्रॉपर्टी है चोरी करके B को दे दी. B went to the wife of A, वाइफ के उसकी वाइफ के पास कहा कि आप इसको छुपा लो, ऐसा उसने कहा है, तो आप इसको छुपा लो. ये इतनी स्टेटमेंट जो है that would become relevant as an explanatory. But if you see from other perspective, that जिस बंदे ने ये सुना या उसकी वाइफ जो कह रही है कि बी ने मुझे ऐसा कहा, उसने तो डायरेक्ट नहीं सुना कि ए ने उसे कहा है छुपाने को. So in that sense it is hearsay evidence. But it is not that only this much of the evidence would result into the conviction. These are the some peripheral fact that somehow would be related to the either supporting or rebutting the inferences, and that's why it would become relevant. Otherwise, the statement of B that A has said to B, A has said to me that you have to hide it, would not be relevant in that perspective, because it is an hearsay evidence. So it is, the conviction cannot be based. But because it explains the conduct, that shows that how why he has to hide it, because A said, and this gives some inferences towards that it wasn't stolen property. So suppose you are able to prove कि एक छाता जो है 24 तारीख को ए ने बी को दिया और वो छाता बी ने उसकी वाइफ को दिया कि आप इसको छुपा के रखो. And if that particular chata, that umbrella, you are able to prove that this is the umbrella that has been stolen, वो किसी का चोरी हो गया था. So in that case, that would create an inferences. So these are, related in case of the circumstantial evidences to support the inferences. The last illustration, F1, that A is tried for the riots and proved to have marched at the head of the mob. The cries of the mob are relevant as explanatory of the nature of the transaction. A के ऊपर ट्रायल है कि उसने राइट्स करवाए, एंड इज प्रूव्ड, ये भी प्रूव हो गया कि वो सबसे लीड कर रहा है. आपने एक फोटोग्राफ किसी जर्नलिस्ट ने, सपोज वी टेक द एग्जांपल ऑफ लास्ट recent, or you can say last year, Delhi riots. In that case, or there is another movie that Gran, that about the 1984 riots in Jharkhand. So that Grahan, in that movie, suppose there is one photograph by the journalist, clicked by the journalist during the riots, and it was shown that you are leading to the mob, आप mob में सबसे आगे हो. So the cries of the mob, उन्होंने कह रहा है कि हमें जला देना है इस पर्टिकुलर कम्युनिटी को. So this cries of the mob is relevant because it is explanatory of the transaction कि आप जिस दल का नेतृत्व कर रहे थे वो दल किस लिए जा रहा था. जब आप ऐसी चीजें कर रहे हो, जला देना है, तो that mean that is of the rights, because the photo जो आपने दिखाई उसमें तो आप लोग को कहते हुए नहीं दिखा ना. So the explanation that A is tried for riot and it is proved to have marched the head of the mob, the cries of the mob. If someone give the evidence, maybe oral documentary or the electronic record, that prove the cries of the mob, that would also be relevant as explanatory of the nature of the transaction. अगर वो मोब ऐसे कहती जा रही कि हर हर महादेव, चलो गंगा नहाने जाएंगे, so that would also be explanatory. If the mob is crying and to giving the threat or their agenda that they have to kill this particular community or the caste, that would also be the explanatory. So these facts would also be relevant. So under section 9, 5 things became relevant. One is, or you can say the first one is that facts that are necessary to explain or introduce fact in issue or the relevant fact. The second is the facts that support or rebut the inference suggested by fact in issue or the relevant fact. Third, the fact which establish the identity of anything or identity of, you can say, uh, you know, anything means thing, identity of a particular object, identity of any object or identity of person. एनीथिंग को मैंने एनी ऑब्जेक्ट बता दिया क्योंकि एनीथिंग एनीथिंग कहते हुए some student are getting confused. So that fact would also become relevant. And the fourth one is that the fact which fix or establish the time at which the fact in issue or relevant fact happened, that would also become relevant. And the fifth one is fact that establish the relationship of the parties by whom such fact was transacted are relevant insofar as that is necessary for the purpose. Okay? So these 5 things would become relevant. Udichi has asked another question, sir. The cries of the mob in this parti particular illustration would they also be covered under the res gestae section 6 and the particular photograph under the section 9 of the established. Yes, cries of the mob would be relevant under the section 6 also. Yes, that is good, because that is the part of the same transaction. And that is not only the part of the same transaction, you can say that actually shows the transaction जो सारा है जो rights जब आपने एक lawful unlawful assembly जब आपने create कर दी, because the assembly of the person, I think you have read IPC, so 5 or more person and they assemble to do some illegal act or act against action can be taken. So that when you done, so that conduct in itself is in the question. But in another sense, you can say that that is relevant under section 6 also as the rest day, and the particular photograph under section 9 of the established identity. Yes, that photograph, if you want to use that photograph, that would also be, yes. Yeah. So these 5 things are became relevant. Now come to the next section. If you have any other question or the query related to section 9, you can ask me, because from my perspective I have explained, and how much you have understand, or if you have any other doubt or anything that you need explanation or anything that you want to share, you are welcome. Yes, guys. Otherwise I will start the next section. Any question, doubt? Yes, please. Yes, ask me. Yes or no? नहीं पूछना तो नो लिख दो. Okay, Satpal, good. Now come to the next section. See, when you see the syllabus there in the case material, the chapter second, and in the section chapter second, you have three parts: part one, part A, part B, and part C. Part A is further divided into two subparts, and in these, after section 9, we have to discuss section 11. And with respect to the conspiracy, there is full-fledged subpart, that is part 2 of the पार्ट ए ऑफ चैप्टर 2. ठीक है, चैप्टर 2, चैप्टर सेकंड है हमारा, वो 3 पार्ट में डिवाइड है, और पहले पार्ट में 2 सब पार्ट है. पहले सब पार्ट में सेक्शन 5, 6, 7, 8, 9 एंड 11, एंड सेकंड सब पार्ट में सेक्शन 10 है, बिकॉज कॉन्स्पिरेसी से रिलेटेड जो है वो प्रोविजन है उसमें, और उसमें काफ़ी लेंदी सा डिस्कशन है, वी कैन से. ओके, एंड दिस फर्स्ट पार्ट में sections 5, 6, 7, 8, 9, and 11. So I'm taking section 11. Section 11 is basically, you can say, make those facts admissible, though as such would not be relevant if you see it. But because they are either giving the inference, okay, so that in connection with fact in issue or in themselves will make the existence or non-existence of the fact in issue or the relevant fact highly probable or improbable. So the fact in issue or the relevant fact you have adduced some other fact that shows that this relevant fact is not possible or it was highly improbable would also be relevant, or it is highly improbable would also be relevant. I'm reading section 11. When the facts not otherwise relevant became relevant, this is marginal note. The facts that not otherwise relevant वो भी relevant हो जाते हैं. Suppose there is a trial of murder against accused A, that on the 7 September 2020 चार्जशीट में ऐसे होता है, A intensely stabs B four times and cause death of B. The fact that you want to prove before the court by oral evidence or maybe by documentary, एरोप्लेन की टिकट और होटल की टिकट लेके आए और कॉन्फ्रेंस की फोटोग्राफ, इधर 7 को तो मैं न्यूयॉर्क में था. So you are not in the place where the offense is committed. For the sake of simplicity, it is Delhi. You were in the New York on the 7th September. If you see this fact in isolation, it is irrelevant. Where you were on the 7th September, how it would be relevant. But when this fact in connection with the fact in issue or relevant fact make it very much improbable that offense could not be committed by the accused A, because that is highly improbable, not impossible but highly improbable. And so this fact that you were not here in Delhi, you were there, this would also become relevant, and by virtue of section 5 you can prove it by oral or documentary evidence. That means you can prove it by evidence, that section 5 से. अब इसको एविडेंस आपने वहां पे स्टाफ की भी गवाही करवा दी, हाँ जी हमारे साथ था न्यूयॉर्क में, एंड आपने वो टिकट्स, एरोप्लेन की, होटल टिकट्स एंड जो कॉन्फ्रेंस जहां आप कर रहे थे वो भी आपने एड्यूस कर. सो दैट टाइप ऑफ द थिंग्स इट basically this section 11 deals with. Okay, So marginal note saying when fact not otherwise relevant became relevant. How? I'm reading section. Facts not otherwise relevant are relevant in two situations if they are inconsistent with the fact in issue or relevant fact. वो inconsistent हैं fact in issue or relevant facts से. Like the fact in issue is that A raped B, and if you able to prove that A is not fit for having sex, so it is inconsistent with fact in issue. Okay. Or suppose the fact in issue showing that A as a public servant did this particular thing, and you shows that he is not in any service, that this particular fact would also be inconsistent with the fact in issue. And the second situation is if the facts by themselves or in connection with fact in issue or other facts they may sorry, I'm reading it again. If by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable, as the earlier example I have given. Illustration, when you will read the illustration A, that the question is whether A committed a crime at Calcutta on a certain day. The fact that on day A was at the Lahore is relevant. Now, this particular fact that A, in the trial of A, that sir, I was at the Lahore, as such, it would not be relevant because this is not in fact in issue. ना तो ये fact in issue में है. Fact is in the fact in issue in the trial of murder that A, suppose it is through the stabbing, A stabs B, by stabbing of B, death of B cause, and A intended to cause B's death. ये simple ले रहा हूँ, बाकी आप 299 का B, C या that you can also apply. But you want to prove that I was in the Lahore. Question भाई से मुझसे क्या मतलब? By virtue of section, though it is not relevant in that trial, but it would become relevant because it is by themselves or in connection of the other fact make the existence or non-existence of any fact or the relevant fact. So here it is becoming highly improbable. The fact that near the time when the crime was committed, A was a distance from the place where it was committed, which would render it highly improbable, though not impossible, that that he committed, it is relevant. So this is explanation to this fact that he was at Lahore became relevant. Illustration B, the question is whether A committed a crime. Suppose in the office, theft was done or theft was committed. Theft तो कोई बाहर का भी कर सकता है. Read the illustration. The circumstances are such that crime must have been committed either by A, B, and C or D. In this case, I am taking वो जो A, B, C, D employees है उसी में किसी ने किया है. The every fact which shows that the crime could have committed by no one else and that it was not committed by either B, C and D is also relevant. So all ये fact कि crime बाहर के किसी ने नहीं किया है और B, C, D इसमें भी नहीं किया है, वो भी relevant हो जाएंगे because the allegation is against A. So these facts that it had not been committed by outside, the fact that it had not been committed by B, C and D would also become relevant because they by themselves or in connection with fact in issue or relevant fact making probable that A has committed the theft, that A has committed the crime. So this A has committed the crime. All these facts that other than A, B, C, D has no possibility to commit it, and B, C, D had not committed it. So these facts are showing that this crime has been committed by A, and that means it is making probable, ज़्यादा possibility करता है, and that became relevant under section 11 part 2. Let's say. Okay. Now there is section 54, and section 54 is basically related to character. In the criminal trial, it's very important. There are 4 sections, 2 related to civil proceeding, 2 related to criminal, and it's very interesting that in the criminal trial, the bad character is not relevant. Past में ये बंदा चोर था, चोरी करता है या ऐसा है, that would not be relevant. That is, very purpose. अगर आप उसी को relevant बना दोगे, then it would be very easy to taking the inference from that side. So उसको relevant ही नहीं किया कि नहीं वो relevant नहीं है. हर ऑफेंस में अलग से ट्रायल होगी जिसमें उसके पास्ट इवेंट से उसका अनकनेक्टेड होगा. But that does not mean that something past you cannot tell if it is relevant by some other provision. But as a conduct, if you want to say नहीं नहीं भाई साहब ये तो है ही बंदा चोर, that you cannot prove because that is not relevant. Previous good conduct is relevant. Bad conduct relevant नहीं है, लेकिन good conduct relevant है. Section 53 and section 54 related to conduct. So in criminal cases, previous good conduct is relevant under section 53, and section 54 previous bad conduct is not relevant. But when you are giving the good conduct कि मेरा बहुत बड़ा good conduct था, ये करता था, उस समय आप bad conduct prove कर सकते हो उसको rebut करने के लिए. Otherwise, as such, bad conduct would not be relevant because that would, have the much, effect on the trial, or you can say the fair trial, that would make the unreasonable inferences. Now, what is the connection of section 11 and 54? That section 11 is talking about that fact that making it highly probable and improbable in connection with fact in issue or the relevant fact. So that means it giving somehow, ये उसकी तरफ इशारा कर रहा है. And then section 54 makes the evidence accused bad character is irrelevant. Such evidence therefore cannot be admitted under section 11 on the ground that his bad character make it highly probable that he committed the crime. Okay. So section 11 part 2, that's saying that the facts which in connection with fact in issue or other relevant fact making it possible the commission is highly probable and improbable. In that situation, in criminal trial, the bad character as such you cannot prove to showing that it was probable that it has been committed by me. It's very relevant. This thing you have to clarify today, otherwise it would create the confusion in your mind. In many sections, like in section 8, it is written that statement does not mean conduct. Statement does not mean conduct. Two illustrations are there, but the statement combined with the or the explanatory of the conduct would also be covered. Okay, so here also, and the statement would not be relevant in that section, but if would be relevant in some other section, that can be proved. But here section 11 and 54 both are, you can say, in same line, and the scope of the 11 you cannot broaden that it can eat the section 54, because the section 54 is making the bad character of a person in the criminal trial is irrelevant. When it is irrelevant, there is no possibility to be become admissible, because it is irrelevant declared. And by section 11 you want to make it relevant, and so it's very important to demarcate the scope of the section 11 and 54. That's why I have explained. There is another section, and that is related to the conduct in the civil cases. There are four sections. The new section, section 53A, was also added, that is related to previous good conduct is relevant. The evidence of character of the previous sexual experience is not relevant. The victim had the previous sexual intercourse, that is not relevant to give any inferences. Section 52 and 55 related to civil, last के, और बीच के 53 and 54 related to criminal. So in section 53, 55, the character as affecting the damage. In civil cases, the fact that the character of any person is as such to affect the amount of damages which he ought to receive is also relevant. In civil cases, section 52, in civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant, except in so far as such character appears from fact otherwise relevant. Here some scope is left out in section 52. In section 55, that is related to amount of damage. So the general rule is that the opinion evidence is inadmissible. Section 45 to 55 recognize exception to this rule, and therefore opinion is not admissible under section 55, cannot be made admissible under section 11, on the ground that it make the existence and non-existence of the fact in issue or relevant fact highly probable and improbable. Section 32, that as a general rule, section 11 is controlled by section 32, where evidence consists of a statement of person who are dead or who cannot be found, but this rule is subject to certain exception when the question is whether the statement of the person who is dead or who cannot be found is relevant and admissible under section 11, although it is not admissible under section 32. So that is also admissible. Some statements that are not admissible under section 32 became admissible under section 11 to showing the particular fact in issue as highly probable or improbable. So that is the scope of the section 11. In case of the circumstantial evidence, like the death of the married woman and the death of the married woman by the burn injury, the chain of the circumstantial evidence was found to be complete. And in that case, that the husband and wife were staying together, these in this situation, some other fact that would become the relevant to showing that the offense is committed by the husband, and it is dowry death. Because the other fact that the bangle were broken, etc., or they were staying together, no one other, there is no other thing that has been stolen, or it is not the case of robbery or other thing. So all these facts would also become relevant, because it make the offense committed by this person as highly probable. So in some trial, in some cases you have said it, and even the investigating agency, as a layman also, you said that by seeing all these situations, all these circumstances, it's not possible that this lady was killed by some outsider, because na to yahan robbery hui, na koi saman toota hai, na all these things. But how you will make these things? Because you have to prove that this particular offense is done by this person beyond reasonable doubt. डेथ हुई, डॉरी डेथ हुई बर्निंग से उस वुमेन की उस घर में, कोई डायरेक्ट एविडेंस है नहीं, आई विटनेस है नहीं, सर्कमस्टेंशियल एविडेंसेस हैं, एंड इन दैट केस सेक्शन 11 प्लेज वेरी इंपॉर्टेंट रोल. Section 11 incorporate this principle of plea of alibi. Plea of alibi. It is known as plea of alibi. Plea of alibi means that at the time when this particular thing is happened, you were not there. PLEA, plea, OF of alibi, ALIBI, plea of alibi. And so if there is a question, there is any objective question that which section contain the principle of plea of alibi, it is section 11. Which section contain the principle of or you can say doctrine of res gestae, section 6. And it is well settled that the plea of alibi must be proved with absolute certainty so as to complete the or exclude the possibility of the presence of person concerned at the place of the occurrence. Okay. In trial, you will listen. In criminal trial, it is very common that plea of alibi. The plea of alibi is raised. But that plea of alibi has to be proved, effectively. It has to be proved to exclude the possibility of his non-presence. And if that is proved, then yes, that would be very strong evidence, not the conclusively, but it is very strong to creating the doubt in the mind of the judge in case of the criminal trial. And so many times the accused do this practice of raising the plea of alibi by first to make it possible that they allowed to give the evidence that they were not there at the time of the crime of the offense. And when they are allowed through the offenses, through the these evidences, they sometimes even prove it, sometimes not even able to prove it. In the many movies you have seen it, वो पहले फिक्स करे रहते हैं कि कहाँ जाना है, किस तरह से वो नाइसली क्राइम कमिट करते हैं, एंड देन प्ली ऑफ एलिबाई रेज करते हैं, वहाँ से पूरा एविडेंस करके एक्सक्लूसिवली कर देते हैं कि आई वाज नॉट हियर, एंड by creating just if you are able to create the doubt, as we already discussed. So criminal trial में that is also sufficient. अगर आप doubt भी create करने में able हो जाते हो, तो that is sufficient. So with that section 11 I have discussed. What is the scope of the section 11? That also we have discussed, that it would not eat out section 54, and how it is related to other section like 45 to 55. That also we have discussed how it is related to section 32. That section 30, section 32 is very interesting section. जनरली आपने इन्वेस्टिगेशन या कोई भी आपने जो भी प्रोसीडिंग हुई उसके बाद में सारी चीज़ें होने के बाद में कोर्ट में एक एक विटनेस आता है, एक एक रिकॉर्ड आता है, और फिर आप उसको कोर्ट जो है डॉक्यूमेंट्री एविडेंस को इंस्पेक्ट करता है या जज, या ओरल एविडेंस जो होता है, जो टेस्टिमनी होता है, वो जज साहब के सामने होती है, एंड इट इज़ एग्जामिन्ड, एग्जामिनेशन चीफ होता है, क्रॉस एग्जामिनेशन होता है, सारी चीज़ें होती हैं। बट इन सम सिचुएशन सपोज द पर्सन इज डेड, अब उस आदमी को तो उस समय जब उसने स्टेटमेंट दी पुलिस की रिकॉर्ड में है, बट नाउ इट इज नॉट पॉसिबल टू प्रोड्यूस दैट पर्सन इन द कोर्ट, उसका क्रॉस एग्जामिनेशन भी नहीं हो सकता, एंड विदाउट क्रॉस एग्जामिनेशन proving a particular thing is not good in the trial, because the cross examination is important to find out the veracity of the witness, but because the person is no more, person is dead, so it's not possible to bring that person before the court for the testimony. And there is some other philosophy also that dying person can cannot lie, but that is not completely true. But that's why these are the reasons under section 32 clause 1. There are 8 clauses, 1 2 3 4. So 8 type of the persons that without cross examination their testimony is admissible, relevant and admissible. Then the person who cannot brought because he is in the the foreign country, and it's not possible, or its production is very costly, etc. In that case also, so all those things in the detail we will read when we will discuss that, or in you yourself can read it, section 32, after this class. Okay, so in that how it is relevant, that also we have discussed. Now with this first sub part of the part 1, part A of the chapter 2 we have discussed, and the time is 6:22, so time would not be sufficient to start the section 10. Section 10 basically, but something we can discuss, that section 10 is related to the conspiracy, and the offense of the conspiracy. If you see that originally the Indian Penal Code was drafted and it was enacted in 1860. So it is known as IPC 1860. And section 120B, that is related to the conspiracy, offense of conspiracy and punishment, that was enacted and inserted by way of amendment. Amendment के बाद में उसको insert किया गया IPC में, original में it was not there. And the conspiracy is something, if you see the stages of the crime, पहले intention बनती है, then preparation, then attempt, and then commission of the crime. Commission of the crime is crime जो commit कर दिया, that is offense, that is punishable in most of the cases, except सुसाइड. सुसाइड में जब आपने क्राइम सुसाइड कर लिया तो दैट इज नॉट पनिशेबल, बिकॉज जिसने सुसाइड किया वो तो है ही नहीं अवेलेबल. अटेम्प्ट सेक्शन 510 511, सो अटेम्प्ट भी पनिशेबल है. प्रिपरेशन भी किसी केसेस में, लाइक द डकौटी एटसेट्रा, दैट इज पनिशेबल. And in the intention stage, the mind framing stage, and in somehow between the preparation, this whole conspiracy that these persons are related to each other. And this was done when this Indian movement, or you can say the independence movement, was there. So it was very difficult to prove the conspiracy. And that's why, if you see that a liberal provision was enacted in the section 10, that is liberal than the English law. So the section 10 basically talk about that in case of the conspiracy, what other evidences may become relevant by virtue of the section 10. So section 10 are making certain other facts also relevant in case of the conspiracy. So the section scope of the section 10 is applicable only in case of the conspiracy. You cannot say that conspiracy जो है और सेक्शन 10 में जो फैक्ट रिलेवेंट हैं वो फैक्ट आप किसी दूसरे केस में भी जहां पे कॉन्स्पिरेसी नहीं हो वहां पे आप नहीं कह सकते. The scope of section 10 is limited in case of the conspiracy. In the marginal note also it is written. Like the motive आप किसी भी केस में प्रूव कर सकते हो. Previous subsequent conduct आप किसी भी केस में प्रूव कर सकते हो. But section 10 are making certain facts relevant, and those facts would be relevant only in case of the conspiracy. So section 10 scope is limited in that respect. Okay. Reading of the section 10 and some more discussion we will done when we will read and discuss in the next class. So with that, today class is over. If you have any question